Recently, a community bank hired me to close a commercial loan. The borrower was a retail business that operated out of a building owned by a trust. Sounds pretty standard, right? Well, not exactly. There was a twist. So here's what happened. The trust that owned the building also owned some investment properties, and the beneficiaries were two brothers. Then one of the brothers died. His widow and the surviving brother worked out a buyout. They agreed that the surviving brother would keep the business and the real estate, and she would be compensated for her late husband's share of the trust. They had an agreement in writing. Everyone was on board. They brought it to the lender and said, "We're ready to close." And that's where the lender came to me, and he said, "Ben, does the borrower have clear title?" And I had to say, "Not yet." Even though the family had come to an agreement, and even though the widow was likely to be the heir of her husband's share, she didn't legally own anything until her husband's estate was probated. You can't just inherit a trust share by a handshake or good intentions. You need a court to appoint a personal representative who then has the legal authority to transfer the interest. The trust didn't identify a contingent beneficiary. You can think of this as the beneficiary who inherits the property from the lifetime beneficiary. As such, his interest became part of his estate. Until the deceased brother's widow probated his estate, she didn't have title to her husband's share of the trust to sell to her brother-in-law. Until that happened, the surviving brother didn't actually own a full interest in the trust, which means that the borrower didn't fully own the real estate, which means the bank couldn't close on the loan. And the timing wasn't great. The existing loan was about to expire. Now here's the good news. This was a local community bank. They were understanding, they allowed some extra time to get the estate probated and clear up title. But if this had been a bigger, perhaps a national lender, or if the relationship had been more transactional, this deal could have fallen apart completely. So what can we take away from this? First, if you're a lender, especially one working with a family-owned business or properties inside a trust, you need a lawyer who understands both real estate and trusts and estates. These issues don't just live in one area of law, and expertise in various areas of law can be very helpful. Second, trusts that aren't clearly drafted or updated can cause real problems. Even with family members who agree, even with written buyout agreements, if the legal structure isn't sound, deals can get delayed and sometimes they can fall apart completely. This one had a good ending, but I've seen many that don't. If you're a lender or a business owner with property inside of a trust and you're looking ahead to a sale, refinance, or a buyout, it's time to get legal advice before you actually need it. Thanks for watching. If you got something out of this, go ahead and subscribe or share it with someone in your network. And if you've got a question about real estate, lending, or estate planning, I'd be happy to talk. See you in the next video.